old issue about the removal of the Chief Justice has been settled by the Agyei Twum case. It's been settled. Even the procedure by which they have to go in Article 146, subclause 6, and going, it has been settled by Agyei Twum case. It says that when you read the Constitution, there was some lacuna that it did not talk about how the Chief Justice should be removed. But in the first place, first and foremost, she's a lawyer.
It did not talk about whether there should be a prima facie for the Chief Justice. So Agyei Twum said, of course, you should make a prima facie before a committee is set up.
Yes, exactly.
Right.
And if I can read this, holding 3, what it actually said on Agyei Twum, it says the court would therefore declare that upon the proper purposive construction of the whole Article 146 in the context of 1992 Constitution, viewed in its entirety, the Chief Justice must be given the benefit of a prior determination of whether a prima facie case had been established against him before the President might lawfully establish a committee to consider a petition for his removal.
Must be giving the benefit of a prior prima facie determination.
Yes.
What does that mean?
Prior facie.
What does that mean?
Now, so the prior facie means that the first sight, right, once you look at it, the Chief Justice is given that benefit. So I'm sure whilst the response has been given, let me just finish, then I can read. Now, it says that whether substance in any allegation level against the Chief Justice in a position, the requirement for prima facie determination will not stop the process of holding the Chief Justice to account. The question of the prior prima facie determination and the subsequent appointment of the committee were to be made by the President in consultation with the Council of State. It will be prudent for the Council of State to evolve a convention by virtue of which the advice of a reputable independent lawyer will be sought as part of the consultative process with the President. So when it comes to Chief Justice and the petition is sent to the Council of State, they have the benefit that they can hire a lawyer, an independent lawyer, to look at the petition.
I think the question arising here is Article 146, Clause 6 does not mention prima facie determination for CJ when the petition is about the CJ.
Yes.
So this case says there must be prima facie before a committee is set up.
Committee, yes.
Does it say in this case that the CJ's response must be sought?
No, it doesn't say so. So that is where it went on and say that the process does not stop at the prima facie case. If it is determined that prima facie case has not been made, that ends it. But if it is made, the process continues. And when the process continues, that is when even you as a CJ, you have a benefit of a lawyer, you have a benefit of an expert of your choice. If it's borders on financial issue, you may have an accountant, you may have an auditor. So the issue where now another layer is being introduced, that at the prima facie case stage, you should be given that response opportunity that I have to respond. I don't think that that was the intendment of it. Because if you see the definition of a prima facie in Black's Law Dictionary, this is what it says: at first sight. So when you bring the petition, at the sight of it, at the sight on the first appearance, on the face of it, so far as can be judged from the first disclosure, presumably, a litigating party is said to have a prima facie case when the evidence in his favor is sufficiently strong for his opponent to be called to answer. So the Chief Justice will be called to answer if, on the face of it, they think that maybe what is stated is that she's taking bribe. I'm not saying this, Chief Justice, please. I'm not saying that's the case. I'm just giving an example. You've taken bribe. This is the evidence. if this is the evidence on the face of it, I see it, then I think that prima facie case has been made. Then the next stage is to give the opportunity to the person to come and respond to it.
When the committee has
when the committee. But what I think we want to
what do you lose if you let them bring their response ahead of setting up the committee?
Yes. So you don't lose anything. That is why the Agyei Twum case is now saying that give the Chief Justice that benefit. Give her that benefit, or give him that benefit to be heard.
Read the words again. It doesn't say give her the benefit to be heard. It said give her the benefit of a prior prima facie determination before a committee is set up. Don't proceed straight away to set up the committee.
Exactly.
Because by the tenor of Article 146, Clause 6, it looks like straight away they should set up the committee until they're ready that there's a need for a prima facie.
Yes.
Right.
Yes. And if you look at the difference between what happened in the Professor Sari case, in that case, they said he brought no evidence. There was no exhibit. Nothing was attached. We don't know the kind of petition that has been sent. That there have been a dossier attached, exhibits that has been attached. Nobody knows the content of the petition. So if that is what has been sent and she's now being given that this is what we have against you. So she has asked for, and the president says, okay, this is what you have. Okay. And let's answer it. I think that is settled.
Very quick on the suits and the injunction application, and then Nana.
I think the suits is become, the doctrine of mootness. It means that when you come to court, what you want, before you come, it has been overtaken by events. So now that the president has provided the petition, the suits and the rest has been.
Do you share in the president's disappointment?
The president's disappointment?
That it seems that the CJ was in a hurry because they were in the process and they were actually going to give her a copy.
Oh, everybody has a right to information. So if she thinks that this is what is in the public domain, I don't know what I'm being accused of, right? I want to know so that I'll be able to prepare for it. I think that it's her right that she would ask for. It's just that maybe it is coincidence that the president, in his mind, his intention was that I want to be fair, I want to be transparent, there should be accountability, I would definitely give it to you. Okay. And she also thinks that I need to look at it and have some experts that will look at it with me.
We'll go to
so I think
Dr.
that
John Osai-Kwapong shortly, but let's hear from Nana Agyei.